Welcome to Come Back with a Warrant.
Welcome back to Come Back with a Warrant with attorney Michael Gottlieb. The American legal system is built on a simple premise. You are innocent until proven guilty. But in the courtrooms of South Florida, that premise is challenged every single day. For 3 decades, Michael has stood between the state and the accused, litigating over 150 jury trials in state and federal courts, from the Florida legislature to the Broward County defense bars. His work is centered on a single mission: protecting the constitutional rights and keeping us free. I'm Lisa Mosby, your host. Let's get started with today's episode, Michael. Most people hear federal charges and assume it's just more serious. But legally speaking, what's the actual difference between state and federal charges?
So a state charge can be a federal charge, meaning you can commit a crime. You can be prosecuted in state court. Maybe they drop it, maybe they don't. They move it over to federal court. It just has to be a nexus, a connection to interstate commerce. So let's just talk about a gun charge, right? If you utilized a gun to commit a bank robbery, and the bullets that were in that gun, or the gun was manufactured in another jurisdiction outside the state of Florida, that can become a federal crime. And in certain circumstances, you may be looking, so for instance, for a gun case, depending on if it's a 942C or a 942G charge, you're going to be facing a 2-year minimum mandatory penalty, where you might not be facing that minimum mandatory penalty in Florida. But the main distinction is that connection to interstate commerce.
Are there other times when cases may end up in federal court, or is it specifically just that interstate commerce?
There's certain crimes such as treason, so on and so forth, but most of the time it's going to be, if not all the time, a connection to interstate commerce. So, for instance, mail fraud, wire fraud. That's going to be, if you committed an act of mail fraud, unless it's somehow exclusively within the state of Florida, it's going to be a federal jurisdiction crime.
How does the initial determination of whether a crime is federal or Florida state impact the investigative agencies involved, like the FBI versus the local police? And then what resources get dedicated to that case?
Well, there's considerably more resources in your typical federal case. Oftentimes the investigations are much longer, they're much broader. From the outset of many of those investigations, in particular with your white-collar crimes and your fraud, they've got an attorney involved from the beginning of that case. The federal government also relies heavily on cooperators in many instances. So if you're committing a crime and you're involved with many other individuals, I found when my client gets arrested, typically 2, 3, 4 individuals have already testified against my client or given evidence or information against my client, especially when I'm representing somebody at the top of the food chain in that criminal indictment. And so that's a major distinction, whereas a lot of cases that are brought in state court are much more street level type cases that don't have the same amount of officers involved, number of agencies involved. The quality of the evidence oftentimes in federal cases is much better than in some of your state cases.
How do federal investigations usually begin? And do people always know that they're being investigated?
No, more often than not, you have no idea that your activities are being monitored. And when I say activities, it could be a search warrant into your bank account. You could be being followed on a daily basis. You might be dealing with a confidential informant and having your day-to-day actions being recorded. So yeah, most people don't know. Many crimes begin with a tip. Typically that's how law enforcement is going to start their investigation. Many crimes begin with officers sitting on a computer watching people. People love to tell on themselves. They love to go on Instagram and show, here I am with a gun, or here I am with cash, or, do foolish things, bragging about how they came into possession of certain items. And law enforcement is looking at your otherwise innocent posts and realizing that those posts came from criminal activity.
Is it true that federal cases almost always require a grand jury indictment, while state cases can often be charged directly by prosecutors?
So that's an interesting question. Both systems rely on indictments, and an indictment is a grand jury being impaneled. There is no defense attorney at that grand jury. It's the prosecutor and the grand jurors. The prosecutor presents their evidence. Florida typically uses the grand jury system for murders only, and in cases of perhaps governmental actors that are being indicted, so that we are certain that there's no foul play between the prosecutor and a governmental actor. The federal government indicts every single case unless there's an agreement between the defense and the government, and you agree to the filing of an information. That typically will signal that you cooperated with the government to help resolve the charge, not necessarily cooperated as an informant, but that the government may come to you and say, hey, look, we're looking at you, we're going to indict you. Here's the mountain of evidence that we have against you. Do you want to, you can come in, you can talk, you can proffer, you can get a reverse proffer, or you can let us go to grand jury and we are going to indict you. It benefits you to hire an attorney, talk to the government, and more often than not, you can convince them to file an information to lesser charges. Although right now, the current federal government is indicting or filing informations to the most serious charges possible.
So, what does this mean for defendants in terms of timing or defense strategy, or, the difference about the court process itself, like judges, bail timelines? I know there's a lot of pieces to that, but can you kind of give us some clarity around that?
So, in addition to what I was just saying, the defense strategy can change because you may often have a longer glide path in the federal system to be able to talk to the feds, to talk to your prosecutor for purposes of refining what charges are going to be filed. The state courts, I feel, act a little bit quicker. Once you're involved in the federal system, many bonds are just based on a signature, meaning that you sign saying you will appear back in court. The federal government's going to find you. If they want to find you, they're going to find you. They have the resources to do so. When you get arrested in the state court system, more often than not, it's based on a monetary bond. So you have to post a monetary bond. In drug cases in the federal court system, there's typically a presumption of no bond. There are significant differences. I've had clients arrested numerous times for drug offenses in state court. They come into the federal system, and it's a rude awakening that it's a very different system, that you have to go through a pretrial detention hearing where the government has to prove you're a danger to the community or a risk of flight, and there's a presumption against you, and you're likely going to remain locked up. So there are significant differences. It's important to get somebody like me who's practiced in federal court, who's tried cases in both jurisdictions, and understands the differences and nuances of those two systems.
And what should someone do immediately if they've been contacted by a federal agency like an FBI or a DEA?
Absolutely call an attorney and understand that your actions might be being tracked. Okay. So whether you're on your cell phone, whether you're on your computer. So there are certain things you may want to refrain from. If you know it's a case that has a victim, don't call that victim. You've been put on notice that you have a case. Call an attorney, call me, get the best advice you possibly can, because I'm going to tell them, come back with a warrant.
How about guidelines? How do the strict, often harsher US sentencing guidelines for federal cases compare to Florida's more flexible criminal punishment code?
I'm not so sure that Florida is more flexible. It really depends on the facts and circumstances, but it's a great
Okay.
question. No, it's really truly a great question. Both systems can really be confusing. Florida's a little more straightforward, and this is what your crime is, this is what your level is, and then you're pretty much stuck there. The federal system, you get a base offense level. You then get mitigating and aggravating factors. Some can drive your base offense level down, such as acceptance of responsibility, timely acceptance of responsibility. If you have more than, if you're at a base offense level of more than 16, you can get 3 levels for acceptance of responsibility reduced. So you can go from a 16 to a 13. If there's aggravating factors, such as you took advantage of an elderly population, or there were more than 50 victims in your case, that's going to drive that number up. The amount of money involved, if it's a fraud case, is going to drive your base offense level up. The federal system is a lot more complicated to understand and deal with, but you have a greater opportunity as well to argue to the judge that your base level should be lower, or that you should be compared. There's much more latitude in the federal system, that you should be compared to a larger group of different defendants, and your sentence should be much more similar to those. The Florida system is a lot less flexible in that regard.
I want to end, Michael, with kind of a recap on why it is critical to have an attorney with specific experience in the federal court system as opposed to one who primarily handles Florida state cases.
So I think, for me, you can find a lawyer who practices almost exclusively in the federal system. You can find a lawyer who practices exclusively in the state system. I prefer my kind of practice. I practice in both. I feel I'm incredibly well-rounded and I'm well-versed in both systems. I've tried cases in both state and federal court and gotten acquittals in both state and federal court. They're different types of practice. The state court system was a phenomenal training ground for me to give me the tools that were necessary to achieve that not guilty verdict in federal court. Only 4 to 5% of all defendants in federal court who have gone to trial have attained not guilty verdicts. So that's rare air that I get to breathe. And I'm not patting myself on the back, but the suggestion is this: most federal cases don't go to trial. Only a rare percentage of them, a very small percentage. So you want somebody who's still in state court, whose feet are wet, who's in the trenches every day, because that person is going to do better for you, in my opinion, in federal court.
And I think we'll leave it there, sir. Thank you so much for your insights today and creating a lot of clarity around this topic.
Yep. Thank you so much. Great Q&A.
Thank you to our listeners for listening to Come Back with a Warrant. Don't forget to like, subscribe, and share this episode for more resources, notable cases, or to schedule a consultation regarding your specific situation. You can visit browardcriminallawyer.com, or you can call Michael directly at 954-682-0999 to ensure that your future is protected by a firm that has spent 30 years in the trenches. And come on back next week.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.